everybody. In this video, we will be covering the topic of admission, confession, dying declaration, and proof, disprove, and not proof. Now, admission. Now, admission has been defined under section 17, and it states an admission is a statement, oral or documentary, or contained in electronic form, which suggests any inference as to any fact in issue or relevant fact, and which is made by any of the persons and under the circumstances herein after mentioned. Now, the next thing that arises, what are the essentials? What are the ingredients of admission? So, essentials of the admission are as follows. An admission is a statement which suggests any inference to any fact in issue or relevant fact. So it provides an answer to the fact in issue which is in question or any relevant fact of a case. It must be made by any of the person prescribed in the act. Now, who are the persons? We will discuss it later on. It must also be made under the circumstances prescribed in the Evidence Act. It may be oral or documentary. Now we will deal person whose admissions are relevant. Now, who all can make an admission under the Indian Evidence Act? Now, firstly, a party to a civil or criminal proceeding or his expressly or impliedly authorized agent as per section 18. Now, this includes the parties to the suit or proceeding or the agent of the parties. Secondly, representative of the parties. Under section 18, the parties to the suit, suing or being sued in a representative character, while they hold that character. For example, the trustees or executors can also make an admission. Next is the persons having proprietary or pecuniary interest in it. This has been given under section 18, subsection 1. It says that in the proceeding, if the statement are made in their character of persons who are interested in proprietary or pecuniary manner, they can make it. For instance, in Shahdev versus Board of Revenue, the Allahabad High Court admitted the evidence of statement of plaintiff's father to effect as to in whose possession the land in dispute was, because he has an interest, pecuniary interest in it. Section 18, subsection 2 talks about predecessor in title. Persons from whom parties to the suit have derived their interest in subject matter of suit, provided statements are made during continuance of their interest. Only when their interest is continuing and it has not become extinct or exhausted, only then the predecessor in title can make an admission. Next, persons whose position is in issue. Now, it is very simple that any person whose position is in issue can also make, an admission. For instance, the board of director of any company. Similarly, this has been given under section 19. It is based on principle that where the right or liability of a party to a suit depends upon liability of third person. Now, any statement by a third person about his liability is an admission against parties. Now, next is the statement by referees, which has been given under section 20. Person to whom a party to suit has expressly referred for information in reference to a matter in dispute. This is what it means by referees. If a man refers another upon any particular business to a third person, he is bound by what this third person says or does concerning it as much as if that has been said or done by him. For instance, somebody takes an opinion. That is what they are referring to. That is statement by the referees. The person who has given the opinion, his admission will be relevant. Now, admission, as we have discussed under 17, another important thing is that admission should be deliberate and conscious act, and in no circumstances can be inferred from gesture or actions. Positive acknowledgement of existence of certain fact is required. Hence, failure of denial or silence cannot be treated as admission. No implied admission can be inferred from silence. Any allegation can be said to have been proved only where there is conscious and deliberate admission in expressed terms. This was held in the case of Mukesh Kumar Ajmera versus State of Rajasthan. Similarly, Section 21 of the Indian Evidence Act lays down that admissions are relevant and may be proved against the person who makes them or his representatives in interest. No, the principle underlying this rule of law is quite clear. It says that it is natural and easy for a man to make statements in his favor. Now, if admissions were allowed to be used by a party who makes them, it will be very easy for one to make a favorable statement before the court. Therefore, such statements are rejected, as nothing would be easier than for a party who had a weak case to strengthen it by making such statements beforehand. Now, Section 17 makes no distinction between an admission made by a party in a pleading and other admissions. The Supreme Court in the landmark case of Basant Singh versus Janki Singh has held that under Indian law, an admission made by a party in a plaint, signed and verified by him, may be used as evidence against him in other suits. In other suits, this admission cannot be regarded as conclusive, and it is open to party to show that it is not true. Now, there are three exceptions to a general rule in which admissions in a person's own interest are admissible. When it is of such nature that if person making it were dead, it would be relevant as between third person. When it consists of statement of existence of any state of mind, or body at or about time when such state of mind or body existed and is accompanied by conduct rendering its falsehood improbable. Now, Section 21 talks about, if the admission is relevant otherwise than as an admission. This is what, Section 21 talks about, as we have discussed just before it. Now, Section 22 states that oral admission as to contents of documents are not relevant unless and until party proposing to prove them shows that he is entitled to give the secondary evidence of the contents of such document under rules hereinafter contained, or unless genuineness of document produced is in question. Now, Section 23 states that admissions are not relevant in civil cases. In civil cases, no admission can be given if it is made either upon express condition that evidence of it is not to be given. Under circumstances, court can infer that parties agreed together that evidence of it should not be given. Now, this was all about the concept of admission. Now we will be dealing with the concept of confession. The word confession for the very first time appears in Section 24. It is a statement which either admits in terms the offense or at any rate substantially all the facts which constitute the an offense. In simple terms, wherein admission of any one fact which goes on to infer that the offense has been committed, or admission of all the facts which goes on to show that a person has committed an offense. Meaning hereby, during the course of trial, an accused might admit to certain facts. Not all, but a single fact which goes on to show that he has committed an offense. But when we talk about admission of all the facts, it says when, during the course of trial, when we will discuss in CrPC, the court asks whether you plead guilty of all the charges. So if he does that, that is what we talk about here. All the facts which constitute an offense. Now, declaration cannot be a confession if it is not made with an intention to confess, or if it does not amount to an admission of facts from which guilt is directly deducible. An incriminating statement which falls short of absolute confession, but from which inference of guilt follows, is a confession within the meaning of this act. Now, it is important that the confessional statement must be voluntary. No, because if confession is obtained by fraud or undue influence, then it will not be confession. The paramount requirement of the confession, of the element of confession, is that it must be made voluntary. For instance, in the case of Kasab versus state of Maharashtra, a Pakistani national was caught alive in the Bombay terror attacks and was charged with serious crimes, including waging of wars against government of India, commission of terrorist attacks, and so on. Now, when he was brought before the magistrate, the concerned magistrate asked him when he first felt like making confession as regards the commission of the crimes that he has committed. He replied that the thought of making it came as soon as he was arrested. He then added that he had no regret of doing it. At another stage of proceeding, he was once again asked why he wished to make confessional statement. He replied that he wanted to set an example for others, to become a fidain like him. This was the confession which was made by Kasab. The Supreme Court held that confession made by him was voluntary. So whatever he stated, that Kasab stating that he wanted to do it because he wanted to attain certain things, because he had been brainwashed. So whatever they had fed him, he wanted to become, in English, if I'm not wrong, they use the word fidain. So he wanted to set an example. That is why he was making a confession. So therefore, it was held that it was voluntary and it will be admissible. Now, a confession, if proved satisfactorily to be voluntary and genuine, is legal and sufficient proof of guilt of the accused without corroboration. But ordinarily, the practice is to require some support of the confession. Whatever confession he has made, there should be some evidences to support it. Confession must be looked at as a whole, not in parts, and it would not be right to take isolated portions of it and to consider whether any of them amounts to an admission of guilt or not. No. Now, the Supreme Court has time and again held that confession and admission must either be admitted as whole or rejected as a whole, and court is not competent to accept only inculpatory part while rejecting the exculpatory part as inherently incredible. Now, the exceptions to the rule that confession to be taken, there are two exceptions. Firstly, it is permissible to believe one part of confessional statement which is inculpatory if there is another evidence to prove its correctness. If exculpatory part of statement is inherently improbable, it may be rejected and inculpatory part may be admitted. Now, the Supreme Court has held that no statement that contains exculpatory matter can amount to a confession if exculpatory statement is of some fact which is true, would negative the offense alleged to be confessed. Moreover, a confession must either admit in terms the offense or at any rate substantially all the facts which constitute the offense. Now, in the case of Bhagwan Singh versus State of Haryana, the Supreme Court was of the view that it is permissible to believe one part of a confessional statement and disbelieve another, that it is enough, it is enough if whole of confession is tendered in evidence so that it may be open to court to reject the exculpatory part and take the inculpatory part thereto. Now, what is the evidentiary value of confession? Now, the confessions are received, in criminal cases upon the same principle as admissions are received in the civil cases. So, in the case of Baldev Raj versus State of Haryana, there was extrajudicial confession of accused before the panchayat, which was coupled with circumstantial evidence. Incriminating articles were also recovered at instance of the accused and motive was also present. The trial court and high court accepted it and convicted the accused. The Supreme Court found no miscarriage of justice and upheld the confession. So, confession, as already pointed out earlier, that if it, supported by any evidence, will be a very relevant piece of evidence. Now, in order, now we will be discussing Section 26, which says that no confession made by any person while he is in custody of a police officer, unless it be made in immediate presence of magistrate, shall be proved as against such person. This is somewhat, similar to Section 161 and 164 of CrPC. In simple terms, if you make any confession before the police officer, that will not be admissible. The reason behind it is that, similarly, Section 25 also states the same thing. A confession made to a police officer shall not be proved as against a person accused to any offense. So the main object of Section 25 and 26 is to prevent the practice of torture by police for purpose of extracting confession from the accused person thereof. No, for instance, it can, it can happen, that out of the fear of police, he may admit to certain things. So, that will not be good during the course of trial in order to give the justice. So therefore, we have this provision. No, that is why we often see whenever a confession is made before the police officer, it is not required to be signed because it is not admissible. Only when it is made before a magistrate, magistrate under section 164, it will be admissible. Now, we will be dealing with the concept of we will be dealing with some of the other provisions of the confession. For instance, section 28 section 29 says that if a confession is otherwise relevant, it does not become irrelevant merely because it was made under a promise of secrecy or in consequence of a deception practice on accused for purpose of obtaining it, or when he was drunk, or because it was made in answer to questions which he need not have answered. Now, this was all about the concept of admission and confession. Now we will be dealing with a very important topic which is frequently asked in exams, which is the concept of dying declaration given under section 32. Now, section 32 states that the statements written or verbal of relevant facts are relevant if made by any of the following persons. Now, who are the persons who fall within the purview of section 32? The person who is dead, the person who cannot be found, the person who has become incapable of giving the evidence, the person whose attendance cannot be procured without an amount of delay or expense which under circumstances of case appears to the court unreasonable. Now, the statements made by a person falling in any of the aforesaid categories are relevant in the following cases. Now, what are the cases? The statement relating to the cause of death or as to any of the circumstances of transaction which resulted in his death, where the cause of that person's death is in question. Such statement is relevant whether the person at time of making statement was or was not under expectation of death. Like in the case of Pramod Mahajan, it was seen that, when he was about to die, just before dying, he was, we can take another example, like, for instance, a person has died and before dying, he was asked, who killed you? And, people have taken certain names. Okay, Mr. X, Mr. Y, Mr. Z, Mr. A, and he nods at someone's name. Then that is, that will fall within his purview and that will be a relevant piece of evidence. The second point under section 32 is that the statement made in ordinary course of business. Then the statement made against his own interest as to pecuniary or proprietary interests of which would have exposed him to criminal prosecution. Statement of opinion as to public right or custom or matters of general interest. Statements relating to existence of relationship by blood, marriage or adoption where the person making statement has special knowledge. Statement relating to existence of any relationship by marriage or adoption between persons deceased relating to affairs of family to which any such deceased person belong or in any family pedigree or upon any tombstone, family portrait or other thing. Statements in document relating to transaction mentioned in section 13 clause A, which is any transaction by which right or custom in question was created, claimed, asserted or denied. And lastly, statements made by several persons expressing feelings relevant to matter in question. This is your, about the dying declaration. Now, section 33 is also important. Section 33 says the circumstances when evidence given by a witness in a judicial proceeding or before a person authorized by law to take it is relevant in a subsequent judicial proceeding or in later stage of the same judicial proceeding. In what circumstances? When the witness is dead, he cannot be found, he is incapable of giving evidence, he is kept out of way by the adverse party, and the presence of witness cannot be obtained unless, without any amount of delay or expense. This was all about, the concept of dying declaration and the, section 33. Now we will be dealing with, the concept of proving of facts, which is proof, disprove and not prove. So in simple terms, as given in the Act, a fact is said to be proved when the court either believes that it exists or renders its existence so probable that a man of ordinary prudence would believe that it exists. A fact is said to be not true, when any of the party produces it, but the court believes that it does not exist, or any ordinary man would believe that it is not, it is not or a man of ordinary prudence would not believe in its existence. And a fact is said to be not, to be not proved when it is neither proved nor disproved. I'll repeat it again. A fact will be said to be proved when the court believes in its existence or renders its existence so probable that a man of ordinary prudence would believe in its existence. A fact is said to be not proved when the party produces any evidence or anything, and the court believes, that it does not exist, or any ordinary man would not, man of ordinary prudence would not believe in its existence. And a fact is said to be, not proved when it is neither proved nor disproved. This was all about the concept of proving of facts, dying declaration, admission, and confession. If there are any queries, please let us know. We will answer them.